When we discuss the larger aspect of Gram Nyayalayas, what exactly is it that we should be covering? From an introductory point of view, we should be looking at setting the context right. Then we must understand the larger intent behind it. Third, we must have a broad idea of the jurisdiction behind or the jurisdiction of Gram Nyayalayas. Fourth, what are the specific inadequacies or the issues with Gram Nyayalayas? And fifth, what is the general way forward as far as Gram Nyayalayas are concerned? If you're able to answer these 5 questions in the necessary depth that we can, I think we should be able to answer a question that comes this year in Mains 2024. So let's begin with setting the context right. And when we do set the context right, what all do we need to cover depending on the length of the question? So if it's a 10 marker, you would write lesser things in context. If it's of course a 15 marker or a 12 marker, you would write more things. Now let's understand this in the context that is to be set. In context, the first thing that we must know is in fact a basic 2-line summary of what Gram Nyayalayas are. So the Gram Nyayalayas or village courts, as we understand them to be, they are governed by the Gram Nyayalayas Act of 2008. Now, first things first, it is an act of 2008. Now, what is the second most important feature of it? It simply means it is for Indian citizens with small claims. Now these claims can be civil, these claims can be criminal, that's all right. The most important aspect of Gram Nyayalayas, which students often don't write, is about Indian citizens who are in rural areas. And the idea of the Gram Nyayalayas Act is to move Indian citizens with small claims who live in rural areas out of the adversarial system. With the necessary procedural assurances of the adversarial system, which means that you still get taken seriously as a structured court, but you're not functioning like a structured court. So with the procedural aspects of it or the procedural assurances of it. So if I had to define Gram Nyayalayas or village courts in a way that I should basically be writing these 5 keywords. The first being that it is governed by the Act of 2008, comes into effect in 2009. It simply aims to move Indian citizens with small claims, civil and criminal both, out who live in rural areas, out of the adversarial system of justice, towards and with the same procedural assurances that you would get in an adversarial system. Now, what exactly is an adversarial system? See, an adversarial system is one of the most important features of the common legal system or the common law system, which India has obviously had a great deal of inspiration from. The adversarial system is that there's always party A versus party B. And the judge is never an active participant in the pursuance of truth or justice. The judge is a spectator, and the judge has to deliver her judgment on the basis of what is argued by party A and party B, or the lawyers party A and party B, before the judge. And because of this, the judge cannot have any bias or cannot be involved in any manner in seeking or finding the truth. This is drastically different from an inquisitorial form of justice, which you would largely find in continental legal systems like South Korea and France, wherein the judge also participates in the investigation of the case, where the judge also participates in examining witnesses or questioning evidences and so on and so forth. In India, the judge doesn't do that. In India, the judge pronounces the judgment on the basis of what is being presented before the judge. And that becomes an extremely important aspect of it. And therefore, when you have part A versus part B, when you have party A versus party B, things tend to just be about defeating the other person. And sometimes, as very popular legal drama called Mamla Legal has said, that sometimes law and justice are not necessarily the same thing. So that can often be lost. So that's the idea. Now, this is the context of it, the summary of it. That's the first part. The second part is, what exactly are you trying to balance? The balancing factor are two incredibly important elements enshrined in our constitution called equality and justice. See, equality and justice indisputably are two key facets of the Indian constitutional scheme that are even as vividly reflected in modern democratic societies and must be upheld at all costs. Now, the principles of equality, the principles of justice, they become extremely important and must be realized by the state apparatus, by the state institutions, no matter what. And the general problem is, and this is where you must understand the context and the notion of it all. See, when you look at India's justice system has a certain set of inherent issues, and Gram Nyayalayas are a response to that set of issues. And our response has been fairly unique. So the idea is, if you look at India's justice system, and we've been speaking about this for the past, 3 lectures or so, there are certain systemic problems with India's justice system. Some of these problems adequately include corruption, delays, procedural complications, pendency, costs, very limited legal aid, the lack of appropriately trained lawyers, non-specialized judges, and so on and so forth. Now, a response to these systemic problems, as we would understand it to be, would often be to solve these problems over a period of time. But the problem with solving systemic problems is that the solution sometimes is longer than expected. So when you're confronted with such a wide array of problems on such a wide scale, what the government has done in response to solve these problems inherently in the justice system is that instead of actively spending time, resources, actively investing in solving these incessant problems of the Indian legal system, the government has responded by creating a system which is not like the current system. It's not adversarial per se, and it still has the procedural guarantees out of it. And this system has been created especially for those people who are in the rural parts of the country, for those voices which are least heard, for those voices who matter the most, not only by population but also by intent and also by problems. And these are the voices that are often exercised most minimally, and this is why it becomes important. And this is how the government eventually comes to the larger idea of what is called the Gram Nyayalaya Act. Now, the historical context is, and this is a very interesting historical context, we used to have something called Nyaya Panchayats. Nyaya Panchayats have been in India since the British times. And post the British times, it still continued in some form or manner. These Nyaya Panchayats, or these royal commissions as they were sometimes called, largely followed substantive law to the T. And they were generally run in a manner which was sometimes very difficult to control, sometimes very arbitrary. But through the 73rd and the 74th Amendment, when it was realized that true power lies with the community, and especially through the 73rd Amendment, where you realized that at least the panchayats must be empowered enough to take policy decisions for themselves and have the resources to implement those policy decisions for themselves. It was after the 73rd Amendment it was understood that there must also be a legal system in and around it which could be supplied with, formal judicial officers, where lawyers could be present, where the police could play a certain role, and you could create truly a third layer of government. Because see, what the Panchayati Raj system does is it creates a legislature and it creates an executive. The executive already was there in the forms of the bureaucracy at the district level and below. It creates the elected executive, it creates your sarpanches, it creates your blocks, it creates your zilla parishad, it creates your heads of these agencies as well. The leg that was missing was the judicial leg. So it truly brings life to the idea of the third layer of government, the third layer of state. And when you create village courts or gram Nyayalayas, which I will tell you in more detail, that they're at the intermediate level, which means that they're at the block level or the samiti level, you'll understand that this is how your LENJ get complete at the local level. So that's the idea behind it. That's the context behind it. So we've had some historical context. We've sort of revamped, restructured, rebranded, uh, completely whitewashed the idea of Nyaya Panchayats, and therefore we've created what are called Gram Panchayats or village courts. And that's the idea. What is also very interesting about something like this is that the Gram Nyayalayas also perpetuate the idea that you would generally talk about in an urbanization question, you would generally talk about in a globalization question, but it also refers to the idea of two Indias. It in fact perpetuates the ideas of two Indias, and this was written by this was sort of reflected in a journal article written by a bunch of legal experts, including Menka Guruswamy, who had also fought the Navtej Singh Johar case, if I remember correctly. Now, how does the Gram Nyayalaya Act have anything to do with the idea of two Indias? This is the rationale that has been given. The idea is that there is a better India in terms of the more equipped India, the more accessible India, the urban India, which has better resources, which has better infrastructure, which has better access, which can afford the courts, which can afford multiple visits to the courts, which has access to the courts, and the other India, which is largely the rural India, the impoverished India, the more disconnected rural citizen, if you'd like to call it that, who primarily gets access, which is to forums that are very, disposal based. So for example, if you go to a lok adalat, and because appeals don't lie to formal courts per se when it comes to lok adalats, the problem with lok adalats is that they're largely built on disposing of claims. They're largely built on finishing cases right there and then, and because of this, the procedural safeguards, the principles of natural justice, the idea of really coming to court gets lost for a large chunk of rural India, and therefore the essential safeguards that a legal system sort of brings with it, the lawyers, the appeals, the procedures, the requirements of evidence, the procedures around evidence, all of that is generally missing in a lok adalat, and we'll talk about the differences between the two also in just a while. But the idea behind all of this is it does perpetuate the idea of two Indias, and it is trying to make the impoverished India as legally accessible as the non-impoverished India. So that's the idea behind it. Now, the act, if you think about it, largely provides for access, or the core provisions of the act provide for setting up, I think, 5,067 odd village courts across the country. Of course, this is still far from reality, but the objective or the aim of the act is to set up about 5,067 village courts. Now, this is to make sure that there is a larger access to justice for the final citizen, for the ultimate citizen, as it is sort of meant to be. So that's the idea, that's the concept behind it, that's the intent behind it, or you could say that's the context behind it. Now, once we understand the context behind it, we must now understand the intent. The intent part of it is fairly simple, which is access to justice, and justice in its true form, which is why Gram Nyayalayas are considered to be one of the most important sort of semi-formal, almost if not fully formal, mechanisms to get justice. And that's something that we must always remember. Moving on, if we look at understanding the general working, the jurisdiction, the key provisions of the Gram Nyayalaya Act, we'll understand certain key features. So first things first, and let's understand this. See, if I have to identify sort of three features that Gram Nyayalayas are effectively trying to do, is that they are sort of hybrid in their working. Now, hybrid does not mean online, offline, as we understand it to be in the post-pandemic world. Hybrid here means a delicate balance of formal and informal legal proceedings. It is formal when it has to be. It is informal when it doesn't have to be. It can give you certain strict timelines that cases have to be heard within X number of days, could be appealed within X Y number of days, have to be finished within a Z number of days. There's a delicate balance around. Second, it sort of has a very tribunal-like set of ways, which means that not in terms of expertise, not in terms of specialization, but in terms of swiftness, but in terms of how prompt they have to be when it comes to addressing cases. And thirdly, it is also largely to do with how indigenous you can be, because at the end of the day, you're dealing with problems of the locals. So that's the idea. If you historically think about it, Gram Nyayalayas are not the first legislative attempt in any form to establish sort of a hybrid or an informal sort of a system which is somewhat located, in a very indigenous sphere of what is called dispute resolution. That's really not the case. Nyay Panchayats, as I told you before, were there, even during British times. Lok Adalats, through the 1987 Act, have already been conceptualized far long ago. So it's not as if they have not existed. Whether Lok Adalats and Nyay Panchayats both have had sort of a very similar objective. So if you think about it, it's about speedy disposal of justice. It's about, slightly informal settings. So if you think about it, Nyay Panchayats, Lok Adalats, or Gram Nyayalayas, they've largely had very similar objectives to fulfill. So what is the difference? Now, obviously, Nyay Panchayats don't exist. So what's the basic difference between a Gram Nyayalaya and a Nyay and a Lok Adalat? There are two basic differences. The first difference is in terms of jurisdiction. Gram Nyayalayas have both civil and criminal jurisdiction, whereas Lok Adalats only have civil jurisdiction. Two, appeals lie from the Gram Nyayalaya. Appeals do not lie from what are called Lok Adalats. The decisions are final and binding at the Lok Adalat level. So you also have those procedural safeguards which are absent in Lok Adalats. Thirdly, it's not a very important difference, but still, if you think about it, it is significant enough. Lawyers are more than welcome to be present in Gram Nyayalaya. Lawyers are actively dissuaded when it comes to lok adalats. In Gram Nyayalayas, lawyers are actively to be present. So this is the primary difference between a Gram Nyayalay and a lok adalat, where a lok adalat simply does not have any of these things, which here, of course, the Gram Nyayalay does, or the Gram courts do. Now, in your exam, I would prefer that you write Gram Nyayalayas and don't write village courts, because obviously the intent is of a certain kind. So we must remember that. Now, so if Gram Nyayalayas are trying to serve the same objective as Lok Adalats, then why did you create Gram Nyayalayas in the first place? What was the primary reason to create something which tends to add to an already existing mechanism? Now, several researches were conducted on this. Several processes were conducted on this. What is extremely important to therefore understand is the way Lok Adalat proceedings were structured, the way Lok Adalat processes were running through. See, Lok Adalats are not bound by, say, for example, the Civil Procedure Code of 1908. They were not bound by the Indian Evidence Act, which is now, of course, the BNA. They are not bound by, any of these laws that effectively give structure to the legal system. So, what was generally reported when Lok Adalat proceedings were observed was that the judges in Lok Adalats tend to be a little more overbearing. They tend to be a little more coercive to the parties that appeared before them and were hell bent on extracting a disposal or a solution to the case. And this was especially true for people who were poor before these Lok Adalats. And therefore, when appeals were absent, lawyers were not there, you were not to be strictly following legal principles or principles of natural justice. There was a great discretion on the judge. There was a great sense of faith that was put in it, and often that faith went unaddressed, and so on and so forth. So the Gram Nyayalayas were set up largely to not have these problems that the Lok Adalats were seeming to process or seeming to showcase. So this is why it existed. You had problems with Lok Adalats. These Lok Adalats were largely coercive, and they were very driven towards disposal of cases. And as a result of this, you wanted to create a larger ecosystem. And that's how the Gram Nyayalay ecosystem comes to the idea of it. Now, so what are the key points that one must remember when it comes to Gram courts or village courts or Gram Nyayalayas? Civil and criminal cases both are to be heard. Some basic procedural safeguards are there. Lawyers are permitted. These are your basic three pillar points. Apart from this, let's get into the technicalities of what the jurisdiction is, how are they to be placed, and so on and so forth. The idea is Gram Nyayalayas are supposed to be the lowest court of our Indian judicial system, the lowest court of our subordinate judiciary, and they would be the lowest court of a subordinate judiciary in a state, and they will be in addition to the existing civil and criminal courts. They will not be replacing your sessions court or your civil courts, which are below the district courts. So district courts, civil and sessions courts, and then village courts or Gram Nyayalayas. The larger set of what it had to be was done on the recommendations of the Law Commission. If you want to quote it for extra marks, this is a 114th Law Commission, which had basically suggested to establish courts like these to sort of provide speedy, inexpensive, and substantial justice to the common man. So we're effectively be looking at, has it been speedy, has it been substantial, and has it been inexpensive? As long as these criteria seem to be met, we seem to be on the right track. Now, under the Gram Nyayalaya Act of 2008, Gram Nyayalayas are to be set up in each state, and they have to be done in consultation with the High Court of the state in terms of how and why and where of it all. And this is provided in the statute itself. The idea is that these village courts or Gram Nyayalayas have to be provided for every panchayat, as I was mentioning before, at the intermediate level. Now, intermediate level, which means you have you have the Gram Sabha, you have Panchayat Samiti, and you have Zilla Parishad. So Panchayat Samiti, and the 73rd Amendment provides for a minimum 3-layer as far as your village ecosystem is concerned, or your rural ecosystem is concerned. And each village court is to be headed by someone called a Nyayadhikari, or a legal head. This Nyayadhikari, as we understand it to be, has to have the same qualification of a first-class judicial magistrate. So this Nyayadhikari is therefore supposed to be a judicially trained, a full member of the judiciary, and therefore is supposed to periodically visit the villages and conduct these proceedings in sort of close proximity to the village where the sort of parties normally reside, and therefore gram courts or village courts are supposed to effectively be what are called mobile courts. In addition to the fact that they have both civil and criminal jurisdiction like ordinary lower courts, it generally works on the fact that courts can take village courts and village Nyayalayas can take cognizance on the basis of an FIR that has been filed. You generally are supported by 2 schedules. So schedules 1 and schedules 2 both have a list of civil and criminal cases. Criminal first and civil second. So schedule 1 has criminal cases, criminal basically crimes that village courts can entertain, and schedule 2 are the kind of civil cases that can be taken up. And the idea behind all of this is to provide a sense of like an exhaustion of lists, that all possible crimes and all possible civil issues that the courts can take up are determined within the jurisdiction itself. And you have sections in the Act which provide for these kind of jurisdictions. And therefore, you can keep adding more and more to this if you require. The central government and the state government respectively can make amendments to these schedules and therefore start giving them more and more powers. So this is largely what the jurisdictional framework is. There are a few sections if you would like to remember, and I'll just walk you through it. So section 3 talks about the establishment of it. Section 11 talks about the fact that you have both civil and criminal jurisdiction. Then you have section 12, which talks about how Gram Nyayalayas can take cognizance over a police report. Section 22 talks about the fact that the judgment that is given in any trial should be pronounced by the Nyayadhikari immediately after trial in open court, and there is a time limit of 15 days to it. Section 24 talks about a civil suit to be disposed of within 6 months, and so on and so forth. So there are a bunch of sections that largely deal with the provisions of it, which we'll of course discuss in terms of what the inadequacies are and so on and so forth. So largely speaking, these are my basic jurisdictional provisions. These are my 3 foundational provisions. The fact that you don't need lawyers is not written anywhere, but it is largely done in practice on ground. But this is largely what your ecosystem is, and it is from here that we can now understand the larger inadequacies as we would know them to be as far as Gram Panchayats are concerned. Now, first things first, the Act does contain certain provisions which are most likely to result into certain issues, and what these issues are things that we have to now therefore get into. The first set of problems that we deal with is with respect to the nature of offenses. Now, what is the larger problem with these nature of offenses? We'd like to understand this in a fair detail. So, we know that Schedule 1 of the Act lists those offences which could be adjudicated by Gram Panchayats. Now, within its sort of criminal jurisdiction, what are the kind of cases that Gram Panchayats can Gram Nyayalayas, pardon me, Gram Nyayalayas can generally hear? Now, theft, concealment, disposal or receiving of stolen property, insult with the intent to provoke, any sort of a breach of peace, basically offenses which are not punishable by death, or offenses with which imprisonment does not exceed more than 2 years are generally included within the jurisdiction of Gram courts. Now, very interestingly, uh, in Schedule 1, Part 1, you have a list of these offenses. There's something called Part 2 of the first schedule. Now, each schedule has two parts. Now, Part 2 of this schedule also lists certain laws, which most people don't know about, certain laws, and if there are any crimes which are committed under these laws, then those crimes also come under the ambit of Gram Nyayalayas. So, and this is where actually the problem lies. You've got Schedule 1, Part 1, and Schedule 1, Part 2. Now, what generally happens with Schedule 1, Part 1 is you're dealing largely with crimes which have a punishment of less than 2 years, cannot be punished by death, and this largely deals with now, as it is called, BNS. It was previously the IPC, and here it deals with other laws which can have any criminal offenses listed under them. So these laws largely could be dealing with, say, for example, the Minimum Wages Act, the Payment of Wages Act, which today is now subsumed under the Labor Code. You'll have the Protection of Civil Rights Act of 1955, which prohibits untouchability. And if you remember untouchability well enough, you know that if somebody gets convicted under the Protection of Civil Rights Act, they're banned from contesting elections for 6 years from the date of their conviction. The Bonded Labor Abolition Act, which effectively is how you criminalize bonded labor, which is also expressly what is called prohibited under Article 23 also. And it also has Equal Remuneration Act and Protection of Women from Domestic Violence Act of 2005. So it largely includes most property disputes. It also includes certain payment disputes. Now the problem is, most of these laws, the Payment of Wages Act, Equal Remuneration Act, and so on and so forth, they largely affect the people who are poor. They're largely social welfare legislations, and social welfare legislations require very careful, very intricate, very sensitive adjudication. Now, this act does not have that kind of a procedural propriety attached to it. Imagine an open village court is discussing an issue of domestic violence, is discussing an issue of bonded labor, untouchability, payments that have not been made. So and these are minimum wage payments, right? So obviously the act does not incorporate the kind of procedural safeguards that it should to handle the kind of offenses the act is empowered to sort of get, look into or address. And this is a very important problem out of this. Now, the second issue that we generally deal with is the larger issue of appeal. And this, in fact, is one of the most problematic aspects of the act. The circumscribed right to appeal. Because generally what happens is, you have a right to appeal, unless, of course, there are certain complications around it, but generally you have a right to appeal. Now, where is the issue? See, the issue is, I think, part 7 or part 8 of the act, part 7, if I remember correctly. Part 7 of the act is the part that sort of deals with uh, how you can appeal and where you can appeal and so on and so forth. And section 33 categorically does provide for appeals in certain criminal cases. Now, where is the problem? The problem is that you cannot appeal against a decision taken in a village court where the accused person has already pleaded guilty. If you have formally pleaded guilty, then there is no appeal anymore. Or, for example, the court has passed a sentence where the fine is not more than 1000 rupees. These are very arbitrary reasons to not allow an appeal. Maybe a person could have pled guilty because of police pressure, because of maybe custodial violence, because the police was playing, very smart. And this is effectively legally unjustifiable. So my problem with criminal appeals very specifically is that your aspects are unjustifiable. I've given you two examples of it. One is if the person has pled guilty, and the second aspect is if the sentence is less than 1000 rupees. The fine is basically less than 1000 rupees. Now, this is largely an issue. Now, the problem with something like this is it creates a very arbitrary ecosystem of your appeals. Now, eventually, there was in the final act, there was a small proviso which was attached, and this proviso said that in case of petitions from 32 and 226 arising due to 32 and 226 or judicial remedies because of 32 and 226 will still be maintainable. But again, these are very difficult to sort of prove. Now, the third issue that we understand within the appeal system is the issue of time. Now, let's understand what the time problem is. See, the problem of time is multifold. One is how long does it take to decide a case. Two, how long do you have to file an appeal once the decision has been made. So with respect to appeal, there is a maximum time that has been granted of 30 days from the date of decision where an appeal can be filed, generally on the basis of a criminal case. Now, there have been several recommendations. In fact, a parliamentary standing committee had also recommended that there is no reason whatsoever for you to have a time limit on appeal which is shorter than your ordinary statute of limitations that apply to ordinary courts. If you're saying Gram Nyayalaya is an ordinary subordinate court, then you have to give it the kind of appellate protections like ordinary appellate courts, and that has not really happened when it comes to Gram Nyayalayas in their own right. So this therefore becomes a problem of contradictory procedure. Now, the next problem that generally it has is the issue of plea bargaining. Now, please understand, plea bargaining is something that is originally provided for in the CRPC, now in the BNSS. Plea bargaining basically means that I tell the court that I am guilty, so I would waste lesser time of the court, and therefore the court, acknowledging my confession, would generally give me a lesser sentence. Now, the problem with plea bargaining here is this. The problem with plea bargaining is that I have to do it without any pressure. I have to do it without any external force. Now, let's understand this. The Law Commission of India, in its 142nd report, had recommended that yes, plea bargaining can work and should work in Gram Nyayalayas because they have criminal jurisdiction, but there should be an independent authority which solves the issues of conflicts in plea bargaining. Now, where is the issue? The issue is that Gram Nyayalaya Act does not have a dedicated, competent authority which can ensure that the plea bargaining is made in an unbiased manner. Because let us say, for example, the accused admitted to a crime, but the plea was denied. Then you go back to an ordinary trial. How will you ensure that the Nyayadhikari is still going to treat the accused in the same way, knowing the fact that the person has already admitted to a crime? In an ordinary court system, you will make sure that this is done in a protected environment and the idea is not known publicly. But how are you going to make sure that this happens here when it comes to the issue of plea bargaining? So, with plea bargaining, the larger problem here is with what is called conflict of interest. And the Law Commission had recommended an independent authority for the same. And this is largely the issue. The fourth problem, I think we can still do it here, is the idea of what is called police assistance. Now, this is a remarkable problem. The Act also seeks to provide assistance of the police to gram courts so that every police officer or official who's stationed in and around the village or the samiti will assist the Nyaya Adhikari in ensuring that trials are conducted and whatever administrative support is to be given. In fact, it binds the police officer or any government servant to provide assistance whenever it is so directed by the courts. Now, there was a parallel study that was done when you were looking at electricity lok adalats, people who had problems with electricity bills and so on and so forth. What was noted in these electricity lok adalats, because they're also very similar to Gram Nyayalayas, is that the police, instead of supporting the system, ended up being advocates and henchmen for electricity companies. And these studies point out how police representatives used to act as lead advocates, not only in criminal matters but also in billing disputes. So you often see people stealing electricity and so on and so forth. And for example, there was another study that was conducted regarding the Shiv Sena courts in Maharashtra, and there also the police were not effectively being unbiased. So in a system which generally has such great compromises to due process of law, and it generally prevents appeals like we've understood it to be, it is incredibly dangerous to provide for police assistance when there is already such conflicts in their local ecosystem. So this is my fourth and final problem that generally exists with what are called gram panchayats or gram courts. And therefore they need to be solved in a certain manner. Now, to understand my way forward, to understand what can be done and should be done in an ecosystem like this, we must go back to our original discussion. See, we have a context, intent, jurisdiction, inadequacies, and now we have to finally figure out our way forward. See, our way forward is very simple. There's a list of recommendations from the Law Commission that you'll find in your notes. You need properly trained judges. You have issues of legal awareness. You should have lawyers who are essentially given some form of incentive. If doctors can be compulsorily asked to serve in rural areas, lawyers can be asked to serve in rural areas assisting these local courts before they finally get to enroll as formal officers of the court anywhere else. So that is that. More than anything else, what you do require is respect for the system. You have to give some amount of credit and force to constitutional values. And unless that does not happen, the entire aim of adjudication, which is justice, will seem to be lost. So my way forward is largely on 3 points: awareness, second sensitization, and sensitization is of all stakeholders, the judges and the police. And third is you have to incentivize lawyers to take up their job seriously and not play favorites. And this answers my larger question on what is called Gram Nyayalayas.